let's approach this by the questions that New Yorkers are posing right now because of what happened to Penny the dog. The first question has to do with, what are the police required to do? It was reported that the New York Police Department said, this is not a crime. The penalties are not criminal. This is a civil matter, and we can't do anything. And it was also reported that they would not take a report as to what happened, or they took a report, but they didn't follow through on it, one or the other. So the question is, what are the police required to do? Look at Section 123. It says this in Section 1 of 123, Part 1. Any person who witnesses an attack may make a complaint of an attack upon a person or companion animal, and other animals as well, to a dog control officer or police officer. Police officer. That's NYPD. It also says this: such an officer shall immediately inform the complainant of his or her right to commence a proceeding. In other words, a court proceeding. And if there's reason to believe the dog is a dangerous dog, which there was, the officer shall forthwith commence such proceeding himself or herself. Look what that says. Penny's owner is saying that NYPD refused to take a report or refused to handle this in a judicial manner, and they denied that the law allowed the police to get involved, but clearly that is not the case. Someone isn't aware of the law or doesn't understand what's in the law. That's not right. All right, so now here's the second question that people are asking. Can Penny's owners, or anybody who jumped in to rescue Penny, for that matter, file a complaint to the court? In other words, bypass the police if they have to. Here's Part 2 of that same law, Section 123 of the Agriculture and Markets Law. It says this: any person who witnesses an attack or threatened attack may, and any dog control officer or police officer shall make a complaint under oath or affirmation to any municipal judge or justice of such attack or threatened attack. In other words, when you witness it, you yourself can bypass the police and make the complaint to the court. All right, third question. What happens if the judge receives a complaint? Does the court have to act on it? If I go to court myself, do I have any right to get a case started over something like this? Well, here's what is said in Section 123 of the Agriculture and Markets Law. The judge shall immediately determine if there's probable cause to believe that the dog is a dangerous dog. Obviously, in this case, there was. And if so, shall issue an order to any dog control officer or police officer, directing such officer, not asking, but directing such officer to immediately seize such dog and hold the same pending judicial determination. In other words, if the judge feels that there's probable cause, they can tell the police, go grab the dog and let's hold on to it until there's a hearing. What happens if the judge is skeptical and doesn't think that there's probable cause? Well, the answer is this. The judge has to hold a hearing anyway, within 5 days, because Part 2 of Section 123 says this: whether or not the judge finds there's probable cause for such seizure, he or she shall, not may, shall, within 5 days, hold a hearing on the complaint. Here's the fourth question. What happens if the dog is determined to be a dangerous dog? Obviously, in this case, these pit bulls were dangerous dogs. So what's going to happen? Well, here's what Part 2 says. If satisfied that the dog is a dangerous dog, the judge shall order neutering or spaying of the dog, microchipping of the dog, and one or more of the following consequences as deemed appropriate under the circumstances and as deemed necessary for the protection of the public. What follows is a list of 7 things that can happen to the dog and its owner. They include the following: confining the dog so it can't escape or interact with the public, keeping the dog leashed when it's in public, muzzling the dog when it's in public, having insurance up to $100,000 to cover personal injuries or death caused by the dog, a professional evaluation of the dog's temperament, and professional training or retraining of the dog. In addition to that, under some circumstances, which the court refers to and the law refers to as aggravating circumstances, the judge can order the dog to be put down or permanently confined. Here's part 3 of section 123. Upon a finding that the dog is dangerous, the judge may order humane euthanasia or permanent confinement of the dog if one of the following aggravating circumstances is established. The aggravating circumstances don't apply in the case of Penny. Here they are. Number 1, the dog without justification attacked a person and caused serious physical injury or death. Number 2, the dog has a known vicious propensity, as evidenced by a previous unjustified attack on a person, which caused serious physical injury or death. Or number 3, the dog without justification, in this instance, caused serious physical injury or death to a companion animal, a farm animal or domestic animal, and has, in the past 2 years, caused unjustified physical injury or death to a companion or farm animal, as evidenced by a dangerous dog finding. In other words, it's like a 2-strike law. It did it now, and there was a previous case that there was an adjudication that it did it on another occasion. So none of that applies here when it comes to Penny. So let's review where we are. Let's review what section 123 of the Agriculture and Markets Code says about the penalties for dangerous dogs, and let's apply it to Penny's situation. Number 1, despite what people are saying, and I'm referring to Penny's owner and the New York Police Department and the local lawmakers and the state lawmakers, anybody who witnessed the mauling of Penny can make a complaint to NYPD. And anybody can make a complaint to the court. The judge is required to hold a hearing within 5 days and can order the police to seize the dog until the hearing if the judge finds that there's probable cause. If there's sufficient proof that the dog is a dangerous dog, the judge can impose a range of penalties to protect the public. And in cases other than Penny's, the dog can even be put down. Section 123 of the Agriculture and Markets Law also imposes penalties for the owner of a dangerous dog. The penalty depends on whether the harm was to a person or an animal and the degree of the harm. So the facts matter. For now, let's focus only on dog-on-dog attacks because that's what happened in Penny's case. New Yorkers are up in arms because they believe there's no penalty when a dog attacks another dog. But that's not entirely true. If a dog is a dangerous dog, its owner is strictly responsible for medical costs if it harms another dog or companion animal, or farm animal or domestic animal. If the victim dog is a service dog or a guide dog or a hearing dog, which was not the case here, but if it is, the owner of a dangerous dog can also be fined up to $400. Now, in Penny's case, the owner of a different dog does believe that her dog was killed by the same pit bulls that mauled Penny. That would make the dogs in Penny's case dangerous dogs, even though there was no prior court hearing. But there's another law that can also apply in Penny's case, and it's a little more applicable, I believe. It's the one that I would use if I was prosecuting. It's New York's animal cruelty law. This is Agriculture and Markets Law, Section 353, and what it says is this. A person who permits any animal to be unjustifiably injured, maimed, mutilated, or killed is guilty of a Class A misdemeanor. A Class A misdemeanor in New York is a criminal offense that carries a potential sentence of up to a year in jail. It's 364 days in jail. Now, there are a few nuances to Section 353 that are interesting. One good one's bad. Section 353 is what we refer to as a criminal strict liability law. In other words, a person can be found guilty for violating Section 353 simply by permitting an animal to be injured or maimed or mutilated or killed. You don't have to know that the law exists. You don't have to be negligent. You don't have to be intentional. You don't have to be reckless. It happened. You permitted it. So there was a prior case called People versus Basile that said 353 is a strict liability criminal law. That's very interesting because it means prosecutors have an easier time because they don't have to prove a mental state on the part of the defendant at the time that the crime is committed. The second nuance is, I'll call it a bad one, but I don't think it's that bad. I haven't been able to find a case where Section 353 was applied to a dog-on-dog attack. So that means that if it's applied in the case of the attack on Penny, this would be the first time it was used that way. And whenever a law is applied for the first time, there's always a possibility that it'll be appealed and more nuances and loopholes will be put into the law by the appellate courts. Now, let me say this. It's not necessarily a bad thing when a law is applied the first time. There's always a first time that a law is applied. I just won a big dog attack case that applied a brand new law for the first time. In fact, it was a law that I had proposed 20 years earlier. Now, are these laws perfect? No, they aren't. And I'll do a separate video about the model laws that should be adopted to plug the holes in existing laws. And I'm talking about existing laws throughout the country, not only in New York. I'll give you a couple of examples. Every jurisdiction should have a dangerous dog law that covers, among other things, that a person should have the right of self-defense against a dangerous dog. If there's no animal control officer around or police officer around. Secondly, another provision that I think is essential is that a person should have the right to take control, to confiscate, to grab a dangerous dog that's wandering around with no police officer or animal control officer in sight. Now, I've authored a model dangerous dog law. A link to it will be in the description below this video. It's at dogbitelaw.com. If you want to search for it on the internet, dogbitelaw.com. And when you get there, do a search on my website for Model Dangerous Dog Law. So are we getting the right picture from what we've been hearing about Penny and Penny's law? Do we need a new law in the case of Penny to handle that situation? Are we getting misinformation? I'd like to know what you think. Put it in the comments section of this video. I'm attorney Kenneth M. Phillips. Thanks for joining me on YouTube. Be sure to subscribe to my YouTube channel for more videos about dog bite law.